If you're a landlord, property manager, or tenant anywhere in the United States, understanding the laws around breaking a lease is absolutely essential. A lease is a legally binding contract, but that doesn't mean it can never be broken. Every state has specific rules governing when and how a tenant can legally break a lease, what obligations the landlord has when a tenant leaves early, and what financial consequences apply. Breaking a lease is not the same as lease termination at the end of a term or eviction for cause. Breaking a lease refers to a tenant ending the lease before the agreed-upon end date, and the legal consequences depend entirely on the circumstances and the state where the property is located. There are several situations where a tenant may have a legal right to break a lease without penalty. Under the Federal Service Members Civil Relief Act, active duty military members who receive orders for permanent change of station, deployment, or other qualifying military orders can terminate a lease with proper written notice, and this right applies in every state regardless of what the lease says. Most states allow tenants to break a lease if the landlord fails to maintain habitable conditions, if the property has serious health or safety violations that the landlord refuses to fix after proper notice. The tenant may have grounds to terminate. A growing number of states allow victims of domestic violence, sexual assault, or stalking to break a lease early with proper documentation, typically a protective order or police report. The specific requirements and protections vary significantly by state. Some states require tenants to provide a specific amount of notice before breaking a lease, even when they have legal grounds. Other states allow immediate termination under certain circumstances, and the financial consequences range from no penalty at all to liability for the entire remaining rent under the lease term. One of the most important concepts in breaking lease law is the landlord's duty to mitigate damages. In most states, when a tenant breaks a lease, the landlord has a legal obligation to make reasonable efforts to re-rent the unit rather than simply holding the departing tenant liable for the entire remaining rent. The specifics of this duty, how actively the landlord must market the unit, what constitutes a reasonable effort, and how damages are calculated, vary significantly by state. Some states have strong mitigation requirements that limit the departing tenant's liability to the period it takes the landlord to find a replacement tenant using reasonable efforts. Other states have weaker mitigation requirements or allow the landlord to hold the tenant liable for the full remaining term regardless of re-rental efforts. Early termination clauses in the lease itself are another important factor. Many leases include provisions that allow the tenant to terminate early by paying a specified fee, typically 1 or 2 months' rent. The enforceability of these clauses varies by state, and some states limit what landlords can charge as an early termination fee. That's why we've created a complete series covering breaking lease laws for all 50 states, Washington, D.C., and Puerto Rico. Each guide breaks down the specific rules that apply in that jurisdiction, including the tenant's rights to break a lease, the landlord's duty to mitigate, military and domestic violence protections, early termination fee rules, and the financial consequences of breaking a lease. Whether you're a landlord trying to understand your rights when a tenant leaves early or a tenant evaluating your options, knowing the specific laws in your state is essential. To explore the breaking lease laws in your state, visit tenantscreeningbackgroundcheck.com and subscribe to this channel. We're covering every state so you have the information you need.